Hi, my name is Hannah Craven. I'm one of the solicitors here at Winston Solicitors in the family department. I specialise in divorce and all family law issues. One question that I often get asked is, how do I get a divorce? And that's what I'm going to talk about today. So, how do you apply for a divorce? Well, in England and Wales, you apply for a divorce on the basis that the marriage has broken down irretrievably. This is the sole ground that you have to rely on. It is now no longer necessary to rely on other grounds such as unreasonable behaviour, desertion, adultery, 2-year separation with consent, or separation after a period of 5 years. You simply make a statement now to the court that the marriage has broken down irretrievably, and that is sufficient. So, how do you go about making an application for divorce? Well, as I say, it's very straightforward. You can make an application now via post. However, most people tend to apply online via the government website. So what will you need to start an application for divorce? Well, you will need your marriage certificate. That has to be uploaded onto the online portal, and you will need to pay a court fee, which is currently £612, although in some circumstances you can have that fee waived. It is possible to apply for a divorce jointly with your spouse, which basically means that you both complete the applications at the same time. Or you can apply by way of a sole application, which means you are the person who makes the application and is in control of the process. The divorce application is completed and is issued by the court, and the court will then send a copy of that application to your spouse, who will have an opportunity to formally acknowledge receipt of that. A period of 20 weeks then has to elapse from the date that the application is issued before the first decree of divorce can be applied for. This is known as a cooling off period and is designed to give people an opportunity to reflect and possibly reconcile, and to sort other aspects such as the financial matters, for example. After 20 weeks has elapsed, you will then be able to apply for the first decree of divorce, which is known as the conditional order. This was formerly known as the decree nisi, but the terminology has changed since the new divorce legislation came into place. The conditional order, as I say, is the first decree of divorce. It does not legally bring the marriage to an end, but it is the first divorce order that you can apply for after the cooling off period has elapsed. Once you apply for the conditional order, you will receive notification from the court as to the date and time when that order will be formally pronounced in open court. And usually there's no requirement for you or your spouse to attend that hearing. Once the conditional order has been pronounced, you will receive a copy of that. And on that document, there will be information to you about the next step and the final divorce order. Now, a period of 6 weeks has to elapse after the conditional order has been pronounced before you can apply for the final divorce order, which will then legally bring the marriage to an end. Now, in certain cases, it may be advisable for you to defer applying to the court for the final divorce order. This may be if there are financial matters to resolve. And it's important to seek advice about the timing of that application before doing so. It may be advisable, however, to defer the application for the final divorce order. There are a number of reasons why this may be advisable, such as resolving the financial issues and/or the arrangements for the future care of the children. Most people often proceed to apply and obtain the conditional order of divorce, which is the first divorce order that I have mentioned. This can be important because if you are able to come to an agreement with your spouse directly or via other means regarding the distribution of the assets, then it is possible to have that agreement formally drawn up into a court order, which you can send to the court for approval once that conditional order has been made. If you have any queries or would like to discuss getting a divorce, then please contact Winston Solicitors on 0113 320 5000.